Adjournment request, if any, from item number 1 to 8.
May it please your honor, lordship, with permission from the petitioner side, lordship, I beg to mention item number 3 and 4, lordship.
Yeah.
Here on behalf of the government, lordship, our advocate general is appearing. Today he is unwell, lordship, so we are seeking adjournment.
3 and 4.
Lordship.
Exactly.
I am for the petition, Your Lordship. Can it be on 21st of November?
The request of the party is placed on 21st of May.
Highly obliged.
Deeply obliged, your lordship.
May I please, Your Lordship? Your Lordship, with due consent of the other side, Your Lordship, I beg to mention item number 2 of the daily list, Your Lordship.
Yeah.
Your Lordship, the assisting counsel is unwell today, Your Lordship. Kindly adjourn the matter for the day.
Item number 2, ASP
number
audit and account service.
Yes, Your Lordship.
You are for the,
Petitioner, Your Lordship.
you have challenged the rule, but that rule is not available on the record.
Yes, it is not available on the.
Then how you can challenge the rule without even placing the rule on record?
Lordship, just kindly adjourn the matter for the day, Your Lordship, because the assisting counsel is unwell today.
You ask them to supply the copy of that.
I have a copy. I have 2 copies, my lord. I'll furnish. I'll furnish.
It's after 2 weeks. Yes.
May I pray for a date, my lord? We have some urgency because the appointments have been made,
Ask the.
my lord. Obliged.
Deeply obliged.
Your Lordship, I beg to mention item number 7 of the daily list. I have taken the consent from the other side. Kindly adjourn the matter for a day. That's all.
Yes.
Any other request? Daily list for admission, item 1.
But item 1, I am appearing for the petition, my lord.
Yes.
But I am appearing virtually, my lord.
Yeah. Yes.
Your Lordship, we required 4 weeks time to file our affidavit in opposition.
But we have already granted you enough time.
Your Lordship, we have not received from the department.
That is your headache. It's not our headache.
Your Lordship, may be pleased to grant another.
So will not grant 4 weeks time.
Your Lordship, 3 weeks may be granted.
3 weeks. Yes, Mr. Saraf.
Well, my humble request is that well, if the department can be granted 2 weeks and the matter can be kept on 18th.
18th of November.
Yes, my lord.
18th would be somewhat difficult for us. Okay. 18th.
My lord, in that case, my lord, till the next date of hearing, there should not be any coercive action from the department side.
We'll see Tuesday on 18th. We'll see. Okay.
Kindly, my lord, direct. My lord, no coercive action till the next.
Then the counsel appearing for the respondent. Please for some more time to file. Reply. Counter affidavit to the petition. We'll stop earlier also. Time was granted on 29/2024. Then counsel for the petitioner shows some urgency. Let last opportunity be granted to the respondents to file counter affidavit to the writ petition placed on 18th as prayed, 18th November as prayed.
Grateful, Lord. Grateful.
Well.
Yes,
Daily list for hearing item 5 and 6.
May I please, Lordship? Lordship, in these two cases, my lord, I am led by Mr. K. N. Chaudhary, my lord, senior advocate, my lord. He is coming, my lord, after some time. my lord.
after
Yes,
some
ma'am.
time now, we don't have any other cases. After one case.
Yes.
Item 8.
Yes.
Item 8.
Item 8.
One week. One. Supplementary.
Sorry for timing, my lord.
Which one? Yeah,
Yes, I for the respondent, the appellant has to start.
yes.
For timing, my lord.
But timing, we don't have any other case. Assignment.
We start point of-
All the other cases have already been adjourned.
My lord, any other day, my lord. Then.
After
After a week. Yes.
supplementary list, item 9 to 15.
Yes.
I am appearing in item 9 only, my lord. Other, my lord, I have no instruction. Notice may go, I think.
No instructions. What do you mean by no instruction?
Because my,
So far as item number 9 is concerned, my lord, a senior, my lord, advocate, my lord, D. Sekhi is appearing today for some reason, my lord, health reason, he could not be present. But in the, from item 10 to 15, there are, my lord, delay condemnation petitions. At least I prayed a notice may be issued in those, my lord.
Delay condemnation is all the matters are same,
Yes, my lord.
will be covered by that.
My lord, actually the petitioners will be different, my lord, at least notice will have to go otherwise. And I pray, my lord, Lordship may allow us, my lord, to take dusty service, my lord, because they are all from Guwahati only, my lord. We can take steps upon them. Dusty also.
In this item number 10, 11, 12. And 15, the IAS जो भी है issue notice in the IA number 2, returnable 3 weeks. Dusty. Registered AD and Dusty.
Yes, ma'am. Good.
In item number 9, list this matter after 3 weeks along with okay, number.
Data alone is.
Yes.
But can I pray for a date, my lord? If possible, if possible, any day, my lord, after the बाद.
वो है लेकिन yes, Mr.
Item number 5 is not today, next week.
Next week.
Yes.
Next week.
Yes.
We already all.
Yes.
Adjournment request, if any, from item number 1 to 6.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 2 and 3. These are review petitions, my lord. I am led by the learned advocate general. He's not keeping well, my lord. He's suffering from fever.
Yesterday he was here.
But intermittently, my lord, he's getting weak, my lord. We have the file, my lord. We could not prepare. I'm just praying for an accommodation of 2 weeks, my lord, with all respect, my lord.
Next available.
I'm so obliged.
Item 7 to 9. Adjournment request from item 10 to 19. Any other request?
Well, from 17 to 21, my lord, there's a series, part series. Here also, my lord, the advocate general is appearing, my lord. Today, for my lord, some health reason is not present. Can it be on a convenient date, my lord?
District,
Also, I am appearing, may it please your lordships.
the.
I'm appearing-
Two districts, their services have been terminated that way.
Yes,
Yes.
Yes, lordships, yes.
21st.
Yes, lordship. I'm appearing for the petitioner lordships. If it is so, if
Yes.
it is so convenient, can lordships keep it on 21st of November, subject to lordship's convenience?
21st of November.
Yeah, it's subject to your lordship's convenience.
We can't say that on 21st of November. Next available bench.
My lord.
Next available. Whenever the bench is available.
Very well, lordships.
Obliged.
Daily list for orders item 1.
My lord, we have filed the IA where we have made a prayer, my lord, as far as upgradation is concerned, we'll file a separate appeal. Only thing is, my lord, lordship will, till the matter, lordship will grant us 1 week's time, we'll file the appeal. Till then, the interim order will operate.
Yes. The matter comes upon for consideration of the IA number 1, so. With the prayer. On behalf of the applicants.
6 to 10.
Grant leave
6
to
to
the,
10, no?
grant leave to them to prefer a separate writ appeal. In respect of applicants number 6 to 10 against the influence judgment and order dated 15/12/2023 passed in writ petition number 630/2021. So the application is not approved by the council for the respondent. Having heard the learned counsel for the parties, after going through the contents of the application, we deem it appropriate to how the IA, the applicant number 6 to 10 are granted leave to file separate appeal against the impugned judgment dated 15/12/2023 passed in writ petition number 630/2021. The appeal will be filed within a period of 1 week.
1 from today.
IA disposed of
My lord, that interim order will operate,
in writ appeal.
the interim order passed in this writ appeal. my lord.
With respect to 6.
With respect to appellant 6 to 10,
Just after, this partner matter or it's a partner?
it's a part of matter.
At least this appeal. Writ appeal number 12 of list is appeal whenever this bench is available. Interim order, if any to continue till next.
Deeply obliged.
Item 4. I am for the opposite party, my lord. I am for the opposite party, my lord.
Wait for the applicant.
Standing Council of Central Bank of India, my lord. They are seeking for 2 months further time, my lord, for compliance.
Password for the time being.
Bye. For admission, item 5.
Lordship, the Central Pollution Control Board has identified weak industry.
Yes, Mr. Who is appearing for the pollution control board?
I'm appearing, in fact. I have gone to the petition. In fact, they are saying that there is a regulation, some brick clean establishment regulation, but there is no such gazette notified regulation as such.
These 2013.
There is no such regulation. There is,
So under which provision you are granting permission to set up the big?
we have an internal guideline. We follow that guideline and some procedures are set. So-
Where are those guidelines?
So we have a,
So any person if agree by establishment of any brick lane is having any remedy
remedies under the Air Act.
under the?
Air Act, if at all, because when we give a consent to establish, we set some conditions which has to be abided by the person who operate the brick lane. If at all those conditions are not violated, then definitely then and there we can withdraw that license.
Which is that provision?
No, those conditions we set in the consent to establish given to every particular brick.
So if any person is agree, under which provision he can ask for this cancellation of permission or whatever? Which provision under the Air Act?
Section 21.
Section 21.
Air Act. No, Section 31.
Power
31.
Guideline, not the 21.
Also 31. This section 31A, Lord.
Appeals. Appeal for the. But state government has authorized any authority to hear appeals.
Yes. Pardon, Lord.
The state government has already authorized some officer to hear those appeals.
Yes,
Any authority,
yes.
which is that authority?
The concerned officials of the Pollution Control Board, regional officers.
Which officer? The regional officer.
Yes.
Where is that? Where are those guidelines?
But here in this petition, he is only targeting upon the brick lane regulation. So his entire case is based upon that regulation. And the guideline issued by the Pollution Control Board.
Even though if we deem it that these regulations are not in force, whatever, what remedy is a person is having against the permission granted for establishment of brick lane? You are saying this 31 is there. 31 says, days from the date on which the order is made, prefer an appeal to such authority. Which is that authority against to which the person is agreed can approach?
Now,
Which is that authority?
in fact, there is an authority which has been, let me have some time so that I can place what authority is running at the moment. Because ultimately, if at all the public is aggrieved by any of the violations, then definitely first remedy they left is that they file a complaint before the deputy commissioner.
Whatever it is.
And
But so far as regarding Mr. how this PIL is maintainable,
Lordship,
how this PIL is maintainable?
Lordship, this PIL
Is establishment of a brick lane in a remote village, you are filing a PIL. If you have any right, you can very well maintain a petition.
it is not in a remote village. The brick lane is established inside the village.
One of the village of state of Assam, how it is a PIL?
Because the local people, the villages are affected,
That
Lordship.
in such matters, particularly a specific matter with establishment of reclaim permission is granted for that, PIL is not meant. You have the remedies to approach the authorities concerned, either filing an appeal before such authority, or to maintain a writ petition, not a PI.
Lordship, let him find out who is the
No,
authority, then Lordship will take
before-
Let him
decision.
find out, it is for you to find out.
Because there is no available records, because there is no notification, regulation, who is the authority, how the people will come to know.
And before establishment is
And if
done,
there is no such remedy, then file a writ appeal or writ petition under Article 226, but not this PIL. They are not supposed to hear division.
Lordship,
Not supposed to hear a matter regarding establishment of reclaim in one of the village, then will be flooded with the litigation. Every person would come against any permission granted by.
Lordship,
Not the actual scope of the PIL.
Lordship, I may be allowed to submit one.
Yes, something.
Brick clean is established one person. He is the one person, but the effect of the brick lease on the adverse effect on the agriculture and the environment, the people at large are suffered.
Who has authorized you on the behalf of people at large? Who authorized you?
I have filed the PIL as a representative capacity.
How many PILs you have filed to date in representative capacity, raising the concern of the general public?
Because it is for the first time such situation occurred in my village. But I'm not going to argue all these things, Lordship. Let him find out the appellate authority. Then Lordship may take decision.
and also before establishment of a brick lane, before we issue the consent to establish, a public hearing is done where the local people surrounding that area are invited along with the representative of the pollution control board. And on the public hearing, if at all any grievance is there, that is taken.
No such public hearing was done in my case.
No, if at all,
Let him produce the documents. Let him produce.
When was the brick lane established?
It was established around 2 years ago.
And now you are challenging hearing after 2 years.
No, Lordship, this 2 years production was not started. They have initiated the process.
Once the permission is granted, bound to, the production was supposed to take place. And if you, for 2 years, you kept quiet.
They have developed the,
Yes, my lord, 4 years, only it was
4 years.
2020.
2020.
My lord.
Testimony on this groundwork.
no reference.
My lord, before the deputy commissioner or any other authority regarding my lord establishment of this.
no grievance is there, Lordship, you give me,
No
Lordship.
representation.
No, so many representation file, Lordship. If I get time, then I'll produce those representations.
Why you have not produced now? With this petition, you have not produced anything.
Lordship, I may be allowed to produce all these things. They represent, so many representations
No,
are
we are
there.
not supposed to. What is this, page 23, what you have? Page 23A? What is this?
Lordship, it is an page, it is started from the It's a guideline on brick manufacturing unit issued by the Pollution Control Board.
So in
Lordship,
these
that is the-
guidelines, there is a provision for revocation. Revocation of consent.
It is says that the notice shall be issued under the Air Act for compliance of the guideline.
It says, sir, condition for revocation of consent. The consent granted will be revoked if it is found that it has been obtained by misrepresentation, default, political control, is found that raw material produced, the industry default furnishing relevant information for the in case of declaration established after obtaining consent board may be renewed without appropriate legal. And follow the project information. You have a remedy, yes. You have a remedy, you approach that authority.
May I submit, Lordship? All right, Lordship, in accordance with the page 23, clause 15 of the regulation,
Yes.
I may be allowed to submit one representation, whatever I have stated in my petition before the authority, and they may take call on it.
Yeah.
Within a specific time limit.
Specific time limit will not provide, you click it. This PIL petition is filed by the petitioner, essentially being agreed with the consent given by the Pollution Control Board in favor of the respondent number. Respondent number 5 for establishing a brick clean unit in village Romadi. Romadi, PO Romadi, District Nagaon. Stop. It is to be noticed that the consent was granted by the Pollution Control Board. The consent for establishing brick clean was granted in favor of the respondent number 5 way back in the year 2020. And this, however, this writ petition is filed challenging the said consent in the year 2024. Otherwise, also we are of the view that essentially this writ petition cannot be treated as a PIL petition. And if the petitioner is aggrieved by the action of the Pollution Control Board issuing license, for granting consent to the respondent number 5 for establishing the petitioner can avail appropriate remedy available to him under the law. At this stage, the concept of the petitioner submits that he wants to withdraw this PIL petition with liberty for the petitioner to approach the concerned authority against the permission, against the consent granted by the Pollution Control Board in favor of the respondent number 5 for establishing brick clean, for establishing a brick clean unit. Full stop. In view of the above, the petitioner is allowed to, but the writ petition filed by the petitioner is dismissed as withdrawn with liberty as prayed for.
Lordship, one more thing. Instead of withdrawn, the word closed may be used. Lordship. It is, the writ petition is closed.
Writ petition is closed.
Closed on withdrawn.
What do you mean by closed and dismissed? One and the same thing.
Yes.
It's okay, please. Don't go by words.
Item 6.
May it please the Lordship. Well, this is a PIL file by an investigative journalist who has worked in all the national papers for the conservation of
No, we have
wildlife.
filed affidavits. Issue is covered by being monitored by the Supreme Court, Malad, same issues, madam. We have filed affidavit indicating everything, madam.
Let me make my submission. My lord, their overzealousness is bringing more seriousness to the issue. My lord, what has happened? The Kaziranga is already is celebrating the 100 years of its existence. And since 18 years, in spite of clear directions of the Supreme Court to notify the eco-sensitive zone, the state government has never done it. They have sent proposals And all proposals of the state government has been turned down by the central government.
Why?
On the ground that state government never put in any integrated corridors. There are 9 animal corridors. But what has happened? A brief facts. The northern boundary is the Brahmaputra River. The southern is the Karbi Anglong landscape. And in between there is a linear, the road. Now the one-horned rhino during the winter, this has been going on through centuries. They move in the winters to the highlands. The highlands are already devastated by mining because the district council there say that they have the power, and there are documents to show. They say that we don't believe in mining 7. Well, this will require some detail. So at page 107, what had happened in 2002 under the prime minister at that time, the prime minister headed the National Board of Wildlife. He took a decision that all national parks and wildlife sanctuaries will have an eco-sensitive zone, and the default zone will be 10 kilometers till the time the state government gives their proposal, because the proposal will be regulation. Assam, especially Kaziranga, never came into the scene, and 21 national parks throughout the country did not give the proposal. So the natural logic is, if it is not given, it will be 10 kilometers from the boundary of the national park. In 2019, the Supreme Court intervened because an application was filed by one Rohit Chaudhary before the Central Empowerment Committee saying that Karbi Anglong, there is massive mining and their habitat destruction has taken place, and unregulated hotels and resorts. Well, look, I want tourism, but not unregulated. The 8 corridors, permanent structures coming up, and they are getting trapped. Then
What the Supreme Court is.
Yes. Supreme Court's order is very important, Lordship. It is at page 170. 17. No. Karbi Anglong. 19. Karbi Anglong. Yes, Malloy, it is at page 118, and the relevant portion is at 124, if I may read. Consider the 118 is the 124 is the operating part. Read. Consider the report dated with respect to illegal mining in Kaziranga National Park. We have asked for the response of the state of Assam. Learned Counsel, appearing for the state of Assam, has prayed for 3 weeks' time to respond to the report. Response be filed on or before 3/5/19. In the meantime, as certain matters are urgent, as apparent from the report, following aspects are mentioned in the report. Ban forthwith all types of mining and related activities along the southern boundary of the KNP and in the entire catchment area of the river streams and rivulets originating in Karbi Anglong Hills, flowing into the Kaziranga National Park. Not permit any new construction, including on private lands which form part of the 9 identified animal corridor. This is very important, Lordship. Director General of Police, Assam, may be directed to ensure that no mining activities take place in the catchment areas of the streams, rivers originating in Karbi Anglong Range and flowing to Kaziranga National Park. Make the Superintendent of Police of Karbi Anglong, Nagaon, Golaghat, responsible to ensure that no transportation of illegal mine materials from Karbi Anglong takes place. In view of the aforesaid, we order that all kinds of mining and related activities along the aforesaid Kaziranga National Park area and the entire catchment area of rivers, streams, and rivulets originating in Karbi Anglong Hill Range and flowing into the Kaziranga National Park, including tiger reserves, are restrained. No new construction shall be permitted on private lands, which form part of the 9 identified animal corridors. The Director General of Police, Assam, and the concerned Superintendent of Police shall also ensure that no illegal mining takes place in the aforesaid area and no transportation of illegal mine material take place from Karbi Anglong Hills. Well, pursuant to this order, what had happened pursuant to the order?
What happened in the Supreme Court thereafter?
Yes, the Supreme Court thereafter, the matter was going on. In the meantime, the Supreme Court passed 2 orders in 22 and 23 on the eco-sensitive zone, where it laid down that the mandatory provisions of the eco-sensitive zone and the OM, the central government's notification of 2011, which specifies any eco-sensitive zone should be under 3 zones. Regulated, permitted, and prohibited need to be strictly enforced. In Assam, what had happened? They gave proposal in 2009, 2015, 2019, all turned down. In fact, I'll read those reports of the central government. The Assam government somehow were not keen on checking the structure coming on in the area. We never know what is the reason. But now the danger is that the CAG reports of the central government states that now you are virtually putting the entire one-horned rhino into destruction because they won't be able to move out. Because once the corridors are blocked, they will die there. And we are going to lose the World Heritage Site because it is the only one, this double horn is in Africa. Well, pursuant to the orders of the Supreme Court, we get an order in the public domain, which is important, Lordship. This is the order which your Lordship has just now asked. What is the stand of the central bank? Your Lordship will come to the second part of my compilation, page 460, second volume, 467.
Before compilation. How are you to say?
But the relevant part is 48.
Brown color.
We filed
My lord, we have filed affidavits. My lord, I'll kindly invite Lordship attention to page 551 of the.
They have not filed affidavit, they have filed an objection before the notice could go.
where is that?
Page 551, my lords. My lord, what had happened in Kaziranga after those directions were passed, my lord, there was a blanket ban. And my lords, there was a IA preferred by the hotel owners, the resort owners, and other other interested parties for modification and recalling of that order.
Before?
The Supreme Court, my lords. And it's still pending. Still pending. And that paper, my lord, page 551, my lord, there's a IA 2890/5 of 22, my lord, wherein the Additional Advocate General Nalin Kohli, representing the state of Assam, my lord, he has said like he have submitted the draft notification has been prepared and it's been submitted, my lords. It's a part of an order dated, my lords. 24/3/2022, my lords. Which 551, my lord. It's still pending. And excuse me, my lords, I have to submit, my lords. I have not done.
Wow, this after 2019, any other orders?
Yes, my lord, there are other orders, my lords. It's still pending though. My lord, there is an order dated, my lords. My lord, kindly come to page number 607 of the meticulous directions of past, my lords. Same issue, my lord, ESL. These are directions, my lords.
607.
607, my lord. It's a part of an order dated, my lord.
Yes.
Yes, my lord. It's a part of an order dated.
We accordingly direct.
Yes, my lords. So we have 9 animal corridors, my lords. We are zealously protecting them, my lords, and we await the approval of the concerned authority, my lord, the highest authority. And once in the order dated, my lords, 24/3/2022.
Even my lord, that order was also clarified, my lord. Page 616.
Yes.
616, Annex E.
Yeah.
Yes, my lord. This was also clarified, my lord. That was also a clarification application was filed before this Honorable Apex Court, my lord, to clarify whether it's a blanket ban or there can be some kind of remission given. So directions also passed, my lord. It was also submitted, my lord. And now it's still continuing, my lord. The issue is same, my lord. Two issues, my lord, animal corridor and the ESL. As I have indicated, my lord, page 515.
So the,
Yes,
the matters in respect of this declaration of eco-sensitive zone in Kaziranga is particularly seized in the seized by the Honorable Supreme Court. How can we issue any direction? There is a if we interfere in the matter at this stage, there are chances we may pass some conflicting orders.
What has happened?
It may be.
I'd like to clarify, my friend, he is confusing the eco-sensitive zone with the mining part of Kaziranga, Karbi Anglong, because the entire landscape is one.
Fine.
The Supreme Court is not in session of any issue on eco-sensitive zone notification. This is,
Kindly,
and the same argument has been taken by my learned friend before the division bench in another similar matter. The division bench, honorable division bench has rejected it on the ground that whatever orders we pass will be consonant.
124 page. Page 124 of your first compilation. One. In Godavan case, this is going on.
Yes, my lord, this is the mining part.
The mining part and what now you are raising what mining
No,
part?
my lord, the mining part is an additional part because when I make my petition on conservation of Kaziranga, I cannot divorce Karbi Anglong part. So my entire thing is that you have not notified the corridors till now because whatever you have
That's what
sent.
that's what
in
the
terms-
Supreme Court is monitoring.
No, that part is not. The Supreme Court is monitoring the mining part, my lord. The
It's
mine-
eco-sensitive zone that the orders which he has referred now. That is in respect of only eco-sensitive
This,
zone.
the government's now case is concerning the entire country. Our grievance is there that what is stopping the Assam government from notifying in terms of the central government's notification? In fact, I was about to read.
We understand that, sir, but once the Supreme Court is seized of the matter where the eco-sensitive zone has not been declared, so far as regarding mining part also concerned, everything is seized with the Supreme Court. Is it advisable for us to pass separate orders in that matter,
Have
sir?
my learned friend being able to submit the proposals which I have sent because rightly or wrongly, I have finding
You have two options, sir. Either you wait for the judgment of the Supreme Court.
Yes, there's a possible issue.
Or please, once the Supreme Court is already seized of the matter, where is the question of issuing notices? Or you may withdraw this petition and approach the Supreme Court, whatever you want. You have two options, sir.
No, my lord, one thing
Since what we are of the opinion, once the Supreme Court is seized of all the matters in respect of whole country, including this Kaziranga National Park, then certainly we are not supposed to again issue another writ for that purpose.
No, but not, in two occasions, your lordship in this court has passed interim orders. I am not seeing an interim order. On the ground that matters were pending in the Supreme Court and the National, the court says that our orders will be not in contrary.
Sir, in those matters, I think so you are referring
In
to
fact-
one Dipor bill.
Yes,
You are referring to one matter in respect of.
No, not the more bill. It is the by drilling in the national park. Your lordship, there's an injunction and on that, the same ground was taken that it is a matter pending in the Supreme. The court says our orders will not be in contrary. It will be in.
My little calmly kind to 614,
In fact,
page number 614, my lord.
614 would take one.
614, point P.
In
Point
case
P.
614, the Supreme Court has also said that if any high court or any other matter takes up, it will be in consonance with our order. So in terms of that, I am seeking.
No, it says
And
another
this
thing.
argument is always
No, no, it says this, in event, there is any substitute.
Litigation, why does the state shying away from
Well,
that? Is he thinking that this PIL is an adversarial?
Sir, please, don't argue in between, sir, please, try to understand. What we are suggesting, sir, since the Supreme Court has already seized of the matter in respect of eco-sensitive zone also, apart from mining, that it is, we are of the view that either you wait for the judgment of the Supreme Court, or you can very well approach the Supreme Court while withdrawing this petition.
I want
Raising your concern.
226 power is too extensive. I want that as matter.
Certainly, we can exercise the 226 powers.
That I want.
But once the Supreme Court is seized of the matter, then it is not advisable for us to again to issue some certain other orders or writ petition or whatever it may be. There are chances that contradictory orders may be passed. Then the state or the other stakeholders will take benefit of that, sir.
No, but we don't want any orders which are in violation. We want the implementation of Supreme Court's
Don't
order.
want any order, but once
Our
the whole of the matter is seized of before the Honorable Supreme Court, it is not advisable for us to go into all this.
But we have
We are
raised
of the
very important issues.
opinion, sir.
In fact, on the first occasion when I made a submission, the first order itself says it's a very serious issue, Lord.
And that's
So I
it
will
was
urge
not-
upon your
it was-
lordship that
it
I
was
can urge.
simply- It was simply
For keeping
observed
the
that
matter
since a
pending.
matter related to green bench list is before the green bench.
But at
other
least I can
organizations-
urge your lordship that since this is a very big matter, large issues are
From the
involved.
submission of the learned counsel, it appears that the matter involves serious issue pertaining to environment, wildlife protection, and therefore the matter pertains to a green bench of this court. But now if we, the facts come before this, that the similar matter is pending consideration before the Honorable Supreme Court, we are not supposed to interfere in all these. At least otherwise, there are chances that it may.
Since your lordship has, this bench has passed similar order, it was my duty as a counsel to place it.
Oh, that's right.
That this order.
So
will
there,
never be-
Mr. Das, you have two options. The petitioner is having two options. Either you approach the Honorable Supreme Court with whatever the grievances
I
you
agree
have,
that let.
or let this petition be pending till the Supreme Court
Yes,
decides.
well, I want the second.
Igor, you wanted.
This PIL petition is filed on behalf of the petitioner raising concern that despite clear orders from the Honorable Supreme Court from time to time, the state government has till date has not declared the eco-sensitive zone / eco-sensitive area in respect of the Kaziranga National Park. Stop. The PIL petition. Several orders passed by the Honorable Supreme Court. In writ petition civil number 202/1995 in re T.N. Godavaran Tirumpalad versus Tirumala
Page 127, 127. Page 127.
versus Union of India as others has been relied upon. It's not. When it concept of the state has raised a preliminary objection that the matter regarding declaration of the eco-sensitive zone in respect of Kaziranga National Park is pending consideration before the Honorable Supreme Court. And from time to time, the Honorable Supreme Court has passed various orders issuing certain directions to the state of Assam as well as the other states. Stop. Learned Council has therefore submitted that when the matter is already seized, when the matter is already under consideration before the Honorable Supreme Court, the petitioner, this writ petition be kept pending consideration till any final order is passed by the Honorable Supreme Court in the above referred case. Stop it. The counsel for the petitioner has frankly submitted that since the matter regarding declaration of eco-sensitive zone in respect of Kaziranga National Park is pending consideration before the Honorable Supreme Court. The matter may be kept pending till any final or effective order is passed by the Honorable Supreme Court on the issue. Stop. In view of the above submissions made by the counsel from the parties, we adjourn this. We are of the view that this PL be adjourned, awaiting any decision oblique effective order passed by the Honorable Supreme Court in respect of declaration of eco-sensitive zone in Kaziranga National Park. Ordered accordingly.
Item 7 and 8.
Who is appearing for the early birds?
7 minutes early bird leave. This is Amsang. Amsang.
This is Yomoto PIL, but we are in receipt of a letter from this early birds, which says that in the year 2013, based on a letter written by the early birds, the Honorable Chief Justice, Guwahati High Court secured the sanctity of and PIL registered. PIL was registered as Yomoto PIL. One amicus curiae was appointed by the Honorable Court, and the early birds provided information through the amicus curiae. However, since the original PIL was clubbed together with the other PIL, forest and wildlife issues, the provisions of amicus curiae case against also seems discontinued, resulting into gaps in providing any further information related to the Amchong. This Guwahati High Court under the above request the honor to appoint an amicus curiae so that we can share update information of the Honorable High Court who appointed the amicus curiae already.
This is the recent letter.
9/8/2024. You are in contact with those people? Or?
No.
Earlier, who was appearing as a amicus curiae?
Yes.
Who was appearing earlier as a amicus curiae in this?
Initially, here Durana appeared, thereafter SSD, and thereafter I am appearing in this matter. Now, if a copy of this letter is
You are appearing as the standing counsel of Guwahati High Court.
Not as a amicus.
no, as a standing counsel, it's since Yomoto was registered.
Yes.
Well, my instructions are very clear, Malak. It's the final draft is under preparation.
The final draft is under
No,
preparation.
we need 45 days because, my lord, when it was registered, my lord, there was a committee formed by the court, its honorable court itself to look into the rehabilitation aspect, my lord. So they have been submitting a report, my lord. We need another 45 days.
That is in May 2024.
My lord.
We have taken note of this fact.
My lord.
That the state cabinet will be required to finalize the submit the operation of the model code of conduct not be placed before the state cabinet now.
Now, that is
already over.
That is gone, my lord. Now another report has come regarding the rehabilitation part, my lord. Because the stress of human stress is also there, my lord. People have populated some areas. So we need to chalk out a plan how to, my lord, without going into conflict with animal, my lord. So rehabilitation committee has also submitted a report, my lord. Problem is that, my lord, pursuant to direction of this honorable court, my lord, the survey of India was entrusted with the responsibility to determine the area of the wildlife center. Survey of India has done their work. Thereafter, some discrepancy or dispute with regard to map of the forest department. So forest department came up with a stand that will reconcile with the map.
Process of rationalization of it has been completed by the forest department. That was the statement made on 27/5/2024.
Thereafter, the matter was placed before the cabinet and honorable chief minister. And thereafter, what is the outcome? That is not known.
That is not there.
That is
Whether it was placed before this cabinet or not?
It was placed before the State Wildlife Board, my lord, and also the cabinet, my lord.
What happened then?
My lord, regarding that, I need some instruction. And then 45 days also needed because Rehabilitation Committee has also submitted its own independent report. There are two reports now. One is regarding the map.
The Rehabilitation Committee is a different thing altogether. First, you have to determine the area.
Area, then only
Then
rehabilitation will
only
come.
who will go, who will in, who will out, who will be in.
I,
Will come.
I have to take instructions specific, my lord. Lordship will point out that.
Okay,
it
and
will help me.
also appearing for the forest department. I submitted that. So far as regarding the. Process of entry of Amchang Wildlife Sanctuary has already been has been completed by the forest department, and the same was placed before the state cabinet for approval. Land Council has submitted that he has no instructions whether the cabinet has proceeded further or not, and therefore some time may be granted for completing the instructions. Full stop. For completing, some time may be granted to furnish the latest factual report on this aspect. Full stop. This court is also in receipt of a letter from Early Birds, an NGO, with a prayer to appoint an amicus curiae so that the said NGO can share updated information to this court through appointed amicus curiae. Full stop. It is noticed that Mr. Das, standing counsel of the Guwahati High Court, is already appearing and pursuing the PIL petition. Therefore, it is advised that the Early Birds NGO may furnish whatever the information they are having to Mr. Das for the purpose of assistance of this court. Full stop. So and so Gogoi for Forest Department is granted 6 weeks time to furnish the latest factual report just after 6 weeks.
Okay.
The 6 weeks time to furnish the latest list as and when the bench is at.
The copy of the letter issued by the earlier, that may be given to me. I'll have a talk with them.
Yeah. ये बिल्कुल सर इनको ये फोटोकॉपी कर
Item 9. Your Lord, was to direct the government to file an affidavit. They have filed it.
Have they filed any affidavit?
They have filed. The person is. Transformer number 1 is please for domestic pipe.
So what is the stand of the state government?
Your Lordship, they have not, your Lordship, to stand as such, they only, your Lordship, annex a copy of the order, letter, your Lordship. It's 12 January 2021, your Lordship. And that was already part of the petition, have annexed. Page 48. There are 6, there are number 4 and 5. 6 5.
Who is appearing for the government here? In para 7, the deponent has given his mobile. He wants us to contact him.
What is your stand?
My stand?
Madam, we asked you to clarify your stand whether you are in the state government is of the view that it should be amusement park or something should be established or not. But what is the stand of the state government? You are opposing or supporting or what you are doing?
As per this is
Yeah.
as per this instruction, Lordship, after inquiry, Lordship, though they have stopped the construction, thereafter they have.
That order is already there. This is already on record. What is your stand about that? Why? The specific order, we have passed this specific order. We are of the proper identification of coordinator. The state has to clarify its stance. What is that clarification? On 30th of May 2024. Yes. What is the clarification you offered here?
Simply take up that subsequently said order was revoked.
That is a fact. We are aware of this fact. This is already on record. What is your stand? Whether you are in this, whatever the municipal corporation or this municipal board has done, you are agreeing with it or not?
To be a study. Legally, they can't support. Very under support.
We are in support.
That is another matter. It's not a way of life. Which one take the government?
Lordships, may I submit something? If Lordships so permit, there could be some clarity on the issue.
Yeah, what do you want to submit, sir?
It is like this, Lordships, my learned friend, Mr. Bhattakur, had brought to your Lordship's notice section 62 and 63 of the 56 Act. But the legal regime has now changed. It is now the onus is entirely on the municipality, how they dispose of the property. The state has no role to play. Those provisions now need to be
Whatever it may be,
shown,
once the state is
shown to your lordships. Now
once
the
the
vesting is
state
absolute.
party, maybe it is within the domain of the municipality. But
Yes,
once the
lordships.
state is party and this court has asked to clarify its stand, then the state is supposed to clarify its stand.
That is right, lordships. But lordship will also appreciate that the consent to establish has already been issued. So I believe once the consent to establish has been issued, that perhaps may be the stand of the state.
So, who prevented them to say so? That we have already.
Well, that is what I thought. I just thought the lordship might just need to clarify the issue.
Who restrained them from doing, expressing their opinion on this matter?
Very true, lordship. Very true. I appreciate. I'm not. I understand fully what is falling from the court, but that since there was a little, so I thought I'll just point it out. Ultimately, in this, we are in this. Ultimately, in fact, if lordships peruses our yes.
State council has not answered it. Let go the view of the economy come. As alternative to find out.
In fact, if lordships so pleases, we had filed an additional affidavit sometime back. In fact, there is no in that if lordship so permits, I can take lordships to that additional affidavit. It would make everything starkly clear that there is neither any violation of the law, neither there is any violation of any other provisions.
Yes.
And what is actually been.
Mr. Consul, because the inquiry, whatever the inquiry was initiated under the instruction of the state government, now they have to clarify that once they have ordered for inquiry, now what are their views? Whether they are in justifying the action of the municipal board or not. That's the only, we just want to know this. Maybe it is within the domain of the municipal board or whatever it may be. We are not, at present, we are not concerned with that. Okay. This PIL petition is filed by the petitioner essentially being agreed with the decision of the Silchar Municipal Board, allowing the private respondent, Assam Progressive Developers Limited, to set up an amusement park in the Gandhi Bagh Park, managed by the Silchar Municipal Board. Full stop. The petitioners have raised a grievance that with the setup of the amusement park in the Gandhi Bagh Park, the nature of the park would be changed and the park would be, the nature of the park would be changed and it may be detrimental to the general public of the Silchar city. Full stop. The petitioner has also pointed out certain. The petitioners have contended that certain irregularities and illegalities have been committed by the Silchar Municipal Board while granting permission to the private respondent to set up an amusement park in the Gandhi Bagh Park in Silchar city. Full stop. The said contentions are opposed by the private respondents as well as the Silchar Municipal Board. However, looking to the nature of the controversy involved, this court, while order dated 30th of May 2024, has directed the state to clarify its stand in respect of the controversy involved, full stop. Thereafter, further opportunities have also been granted to the state to clarify its stand, and pursuant to that, an additional affidavit is filed on behalf of the
Number 1 and 3.
on behalf of the urban develop, on behalf of the secretary, additional secretary to the Department of Housing and Urban Affairs, secretary to the Government of Assam Urban Development Department, and joint secretary to the Government of Assam Urban Development Department. Having gone through the said affidavit filed on 5/9/2024, we are of the view that instead of clarifying the stand of the state government, the deponent has simply mentioned certain facts which are already brought on record by the respective parties. It is very sorry state of affairs that when the state government, when this court has sought, when this court has directed the state government to clarify its stand on the issue raised, the additional affidavit, the affidavit is filed on behalf of the state government in a very casual manner. Stop. It is a serious matter where the authorities of the state are taking the orders of this court in a lightly or in casual manner. Full stop. However, in the interest of justice, we direct the pointed queries made by us. On pointed queries made by us, learned counsel appearing for the state has failed to satisfy this court, and also not able to clarify the stand of the state government. Full stop. Hence, we are left only with the option to direct the state government to file an elaborate affidavit to clarify its stand by the next date of hearing. We made it clear that if the state, if the state fails to clarify its stand on the issue, we will be forced to summon the secretary to the respective secretaries to the respective departments. Full stop. List as and when the next this bench is available.
Published. Grateful lordships.
Item 10.
The working plan of the forest division, madam. The most of the forest division without the working plan. The in person with the last order, my lord. That is 28/8/2024, my lord, Karbi along has to file their affidavit.
Yes.
Last occasion when I had pointed, given some instructions out of the certain plans we have finalized, and regarding the forest working plans of those divisions falling under the autonomous councils, madam, these are awaited, madam, these are pending.
They are depending.
What had happened basically, my lords, originally these autonomous districts, they had 2, 3 districts within them. But now they have created few more districts, which increases the number of divisions. That has acted as a hurdle, my lords, in finalizing those plans, my lords. They are into this council for NH, Dima Hasa is there.
We have implemented.
Karbi Anglong is there.
Three councils.
Yes, madam.
Now they are equalized.
BTC is there.
This
Karbi Anglong is there.
Bodoland Territorial Council, who is appearing for Bodoland? Karbi Anglong Autonomous Council and this Dima Asau Autonomous Council. So all you have already filed your response. And what about this Bodoland? And Karbi Anglong?
But Karbi Anglong, I have to repeat the instruction, my lord. Out of the 3 divisions we have with us, my lord, in 1 division we have already prepared a working plan, it is submitted to the government. And the another 2 divisions, my lord, newly created Karbi Anglong with the district, my lord, it is under process, my lord, that has not been submitted.
By what time will
My lord, at least 4 weeks time, but
pursuant to the direction given by this court on 25/7/2024, the Bodoland Territorial Council and the Dima Asau Autonomous Council has already submitted their response. However, the Karbi Anglong Autonomous Council has not filed its response till date. Mr. Council appearing for the Karbi Anglong Autonomous Council has submitted that in respect of there are 3 divisions falling in the Karbi Anglong Autonomous Council area, and out of which in 1 division the formalities have already been completed. However, in respect of 2 divisions, the process is going on. Stop. Mr. Council, Mr. So please some 4 weeks time to place on record the response of the Karbi Anglong, to file the response on behalf of the Karbi Anglong Autonomous Council on the issue involved in this PIL petition. List after the list on the available.
Or hearing, item 11.
লিখাটো কর আমি যে মই লিখিছিলো
My email lordship based on the queries raised by these honorable court on the last date of hearing lordship. Regarding the queries raised by these honorable court on the last date of hearing lordship, so I have some certain instructions from the department lordship. These are
লিখা আছে
points 1 and 2 lordship. Record. Now they have replied to
Lessons.
more time.
মানে মই just more than photo order kita ko ini tapi from the North Pole of the night 25th meter. আমার এরকম করতে মানে আমার চাকরি এবার এইটো না যে মাতিছে
In the lead.
810. Petitioner number kiman for respondent.
ग्यारह में 8 not completed. What do you want? What do you want?
My lord, if your lordship would kindly have a look at order dated 15/12/21. My lord, we have all readily is available there. My lord, this aspect of the matter was gone into. Kindly see, my lord, 15/12/21. Please come to the first subpara, my lord. Yes.
Yes.
A person to first subpara, pursuant to our order dated 7/12/21, Principal Secretary, Home Department, Government of Sikkim has filed an affidavit. The aforesaid order dated is reproduced below. Art Sri so and so. During the course of argument, it transpired that rules of business framed under clause 3 of Article 166 of the Constitution needs to be seen. Let a copy of the same be placed before this court. Now, this is important. In addition to the above, let an affidavit be filed by the secretary level officer of the Government of Sikkim, bringing on record whether the office memorandum dated 22/11/95, which was impugned before the single judge, was passed by the Governor of Sikkim in exercise of his power under Article 371 FG of the Constitution. List the matter again on 15/12/21. Although a copy of the entire rules relating to allocation of business, namely so and so, has been enclosed with the affidavit filed by the Home Secretary, Government of Sikkim, the reply seems to be evasive in as much as it does not explain in clear language whether memorandum dated 22/11/95 was passed by the Governor of Sikkim in exercise of his power under Article 371 FG of the Constitution. What have been stated in paragraph 5 and 6 of the affidavit reads as under. I say that the notification dated 22/11/95 has been issued with objective of identifying the Sikkimese citizen and non-Sikkimese citizen as referred to in proviso to Rule 44 of the Sikkim Government Establishment Rule 1974, through the means of issuance of a certificate of identification. I say that the said notification and the subsequent notification memoranda dated 27/9/96, 25/2006, and 26/2012 were necessitated in order to make the said proviso to Rule so and so workable. I say that the said rule is peculiar to the state of Assam, Sikkim, and enjoins the constitutional protection of Article 371 F of the Constitution. I say therefore that exercise of the power by His Excellency, the Governor of Sikkim, while issuing notification dated 22/11/95, is traceable to the power conferred upon Governor of Sikkim violated Article 371 FZ of the Constitution of India. Not important. We must record that our query remains unanswered and there is no reply as to whether memorandum dated was passed by the Governor of Sikkim in exercise of power under 371 FG of the Constitution of India. Well, this is how they are dealing with the matter, my lord, for the last couple of years. Two honorable Chief Justice of this honorable court, my lord, has gone to Supreme Court after dealing with this. The crux of the matter is these impugn notifications, whether these were issued by the, in fact, before the learned single judge also, they never produced the record. And before this honorable court also, in several other earlier occasions, my lord, though opportunity was given, they have not produced the records. Twenty-five, 11 to 1. 95 to 9. Single judge का तो ऐसे नहीं point to judgment नहीं impugn judgment. In
Yes. So now what do you want?
I'm just looking for some more time.
How much time?
My senior government advocate wants to meet over the online line.
Okay, fine. Yes, Mr.
My lords, my instructions are, my lords, we may be given 6 weeks time, my lords, to earnestly look into it, my lords. My lords, what has, my lords,
Advocate,
my lords,
whatever this letter says,
my lords,
this September 13, 2024 is written by you.
yes, my lords,
And it is that the court has raised certain queries.
yes, my
But
lords,
since the record is not available, we think that you will not be able to satisfy those queries.
Yes.
So whatever it may be, whatever the available record is available, whatever the material is available on record, will go by this.
my lords,
and consider this.
my lords, in fact, my lords, what has happened after the last 8 days, my lords, we had appraised the highest authority, my lords, including the HCM, my lords, about the, my lords, the anxiety of the court,
It
my
is
lords.
beyond your control. Since the record is not available, what you can do?
Yes, my lords, we are earnestly looking into it, my lords, trying to find the
If
records,
it is not available, it's okay. But
my lords.
whatever the material available on record, we'll go through it and we'll pass and we'll hear you.
Yes, my lords, then, my lords, then in that case, my lords, a date will be given, my lords, to us, my lords, and on that day, my lords, if it's available within that time, we will produce it, my lords. If it's not, then we'll go ahead with the hearing.
States should be fair to this honorable court, my lord. In 2015 itself, they say they filed an FIR. 2015. Today we're in 20. This is a letter written by Joint Secretary Land Revenue Department to the officer in charge Sadar Police Station, Gangtok, Sikkim, on 25th of June 2015. They say this is to bring to your notice that 3 files pertaining to notification bearing notifications dated so and so, so and so, so and so has been missing from this department since time unknown, and in this connection with the same, this FIR is being launched.
This notification in respect of 1995.
No, not 95, but others, my lord. 96 connected ones. All the other than 95 others.
My lords, in fact, my lords, on the last date, we had a full day hearing, my lords.
So when that will do. So we have heard the matter. We
Yes,
are
ma'am.
aware of that full day hearing or half day hearing. We are aware
My
of
lords,
that.
my point is that we are not trying to evade or we are not trying to prolong the matter, my lords. It's only, my lords, we are trying to try and look for the records, my lords. So, my lords, if it's not there, my lords, we will hear on the next date, my lords.
No, my lord.
No, if it is not there, what do you will do?
Well, consequences will follow. Section 114 Evidence Act is there.
Yes, my lord, sir.
We'll take into consideration whatever the material available here.
My lord, sir. My only prayer is, my today I was unable to produce these records, my lord. That is why I'm seeking a date, my lord. If my lord, dates may be given, my lord, on the next day we'll hear the matter. I am.
My lord, there is one aspect, my lord, Lordship will kindly consider. Now, the persons would be benefited by the order of the single judge, my lord. Now, order of the single judge is not stayed. My lord, so many
Contempt petition.
only contempt part, only some observation has been made. Now, the question is, my lord, for example, in one of the student, my lord, he has appeared in the Sikkim Civil Service examination. Now, everything is over, my lord. The interview is fixed on 7th of November. Now, my lord, he is not being issued. Let them do, my lord, subject to outcome of the writ appeal. My lord, these students are suffering.
We'll pass an order.
Okay.
No
The only thing is,
Well,
my lord,
child-
okay, we'll file an IA.
File an IA, then file a response to it.
Yes, we'll do that. Since there is no stay, unnecessarily they're withholding, my lord.
Acha, Mr. Kapil, see, these things you have mentioned in the order, these are obviously not reflected in the last order. This must have been a part of the deliberation. We are not doubting it. But specifically, we asked you to file a written note on submission. Where is that? Is it already on record? Both sides.
We have
Yes,
given
ma'am.
long back.
अच्छा बेलेग bunch के ऊपर लिखा है ये तो नहीं this is written note. Okay.
If necessary, we'll give. If necessary, we can give one more set, my lord. We have given.
No, these are very bulky.
I think my junior will verify, my lord.
Written
If it is not
submission.
done-
Gist of the written submission is what you have almost filed another petition here. Who will read this?
This writ appeal was heard in part on 29/8/2024 at length. Full stop. During the course of arguments, certain oral queries were raised by this court. And the state of Sikkim was supposed to clarify, supposed to answer those queries. Full stop. Learned counsel appearing for the appellant has submitted that for the purpose of satisfying the court about those queries, some old record is required to look into. However, the same is not available because there is all probability that the same is either missing or destroyed in the devastating earthquake took place in the year 2000. The earthquake took place in year 2011 in the state of Sikkim. Stop. With that as it may, see, if the record is not available with the state of Sikkim for reason for the reasons beyond their control, we deem it appropriate to hear the parties while taking into consideration whatever material available on record. Stop. Then it concept for the appellant raise some time so that the learned Advocate General for the state of Sikkim may come and argue the matter, may appear and argue the matter. Full stop. List on 18th of list on 19th of November 2024.
Malaj, I humbly pray, Malaj, if it could be, Malaj, on that week, I have some difficulty, Malaj, if it could be a little bit later, Malaj.
Date we are, we say
Malaj,
of November, you have a difficulty.
Malaj, I humbly,
November, you have a difficulty. What is this?
Malaj, on the last, this is the last occasion, Malaj, I humbly pray because I've.
immediately the given date and you have an objection about that.
My lords, if it could be earlier, my lords, if it could be earlier, my lords.
Yes.
Please request the Advocate General to arrange a schedule and please come here on 19th of.
My lords, if it would be earlier, my lords,
The senior counsel, who is Advocate General in Tripura, is engaged a special counsel.
Oh, sorry, Advocate General. Okay, we'll clarify.
My lords, if it could be, my lords, if it could be on 14, 15, my lords,
You
earlier.
You ask Leonard Senior Counsel to arrange the schedule, please. Please
My
try
lords.
to understand, we are also concerned, this is the special bench. We
Yes, my
can't
lord.
form it as per your choice. We have so many matters, not only this matter, sir.
My lords,
Please try to understand.
I bow down, my lords.
Okay, 21st of November.
My lords, actually, my lords, I, with my folded hands, my lords, I'm just requesting, my lords, my difficulty is, my lords, my father is a liver transplant patient, my lords. I am taking him to Hyderabad during that week, my lords. Because of that reason only, my lords. Because of my personal difficulty, my lords. I am not.
Instructing counsel.
Yes. We are instructing counsel, please. We are fixing it on 21st of November, sir.
My lords, let it be on 18, my lords. My lords, let it be on 18 then, my lords. Let it be on 18, my lords.
No, 18, no, not 18th. 18th is not the hearing day and 21st of November. 21st of November.
Milord, if he is having some difficulty on 18, let it be preponed, Milord.
Sir, 18th. We have given this the 20th of November. 21st of November, sir.
21st of November. I'm sorry, Milord. Let it be preponed, Milord. He is also having.
Prepon will not be able to form this bench, sir. मुश्किल होगा हमारे लिए problem ही है. Because to have all this.
So let's put it
You
be
agree, both of you.
26th, Milord.
26.
Yes, my lords.
26.
Yes, my lords. I'm grateful, my lords.
26.
Deeply. And my lord,
Deeply
will
obliged,
finally I will make a mention, Milord. Yes,
That you can do.
yes, yes. 26.
While supplying advance.
I will supply a copy.
Yes, my lords. Grateful, my lords.
Item 12 to 16.
These are those FPSC matters where Lordship asked us to submit a detailed list of them. We have come prepared with the list of things. Yes. Perhaps, my lord, the only perspective of the government and public service commission could be, my lord, that this should not operate as a precedent. Otherwise, my lord, when APSC, the authority, mandated to make this election, has taken a stand. And my lord, I don't think government has any role there, my lord. Once the APSC makes the recommendation, duty of the government is subject to police verification and etc. They have to give appointment. Therefore, my lord, in these circumstances, if a lordship exercises the discretion, I don't think government will have any say in the matter. Kindly see, my lord, the matter was hard, or matter was kept pending for 2 years, then the judgment was rendered, making the whole scheme of things, my lord, murky.
They would not have gone to that. But their problem is put out of sight from there. Principle, principle if we apply that. Yes. And it's actually relevant here because the statutory body. Statutory.
There are two set of petitioners.
Yes.
One, the petitioners who have passed the preliminary examination initially, but when the result was revisited,
Then it was found out not to have cleared the prelims. That is,
those
yes,
are
my
your
friends.
and your clients, they have not passed the preliminary examination, but
Were permitted to appear
permitted to appear.
and we came out successful. And the stand of the APSCs, my lord, the preliminary is only a screening. Eventually, the merit is judged in a main written examination and viva voce.
But if the principles of Article 14 is applied strictly, then your clients have difficulties.
My lord, if there is difficulty, then the difficulty is across the board. Now the question is, lordship will exercise the discretion with all humble submission I am making. It's a question of exercising a discretion in the peculiar facts and circumstances. I will kindly appreciate one aspect of the matter. Before the learned single judge, the issue was something. The learned single judge came up with a different version of learned single judge's view. That too after more than 21 months. Not all the things are crept in. Therefore,
Nobody could do anything. They will actually be allowed to participate. If participants will not go out. Oh, a lot of people are. Despite being aware that they are not here. But they are here. Eligible, what is the purpose? If you clearly mention, then we'll consider. That will be reference point. The state is not telling you.
and my lord, as far as the two writ petitioners who could not clearly, qualify in the prelim, that the issue was my lord, wrong answer key. Even after the first.
Mr. Chaudhary, if we recapitulate, your clients did not pass the prelims.
Yes,
They came to the High Court saying what?
we say that these answer keys are wrong.
Hmm.
If our answers are properly evaluated, then we will prove.
Okay, so after the answer keys were properly evaluated,
Yes.
then
No, it was never evaluated.
it was never evaluated. So
Understood at that level.
learned single judge passed an interim order allowing your clients to participate.
Yes.
Correct?
Yes.
And the final judgment came after 21 months, you say?
Yes.
In between, the entire selection process was complete.
And my lord, the stand of the APSC was also, in fact, the learned single judge insisted on the stand of the APSC both the sets of petitioner. And in respect of both the sets, the stand of the APSC was, we have no objection since preliminary is only a screening and they have cleared both mains as well as viva on their own merit.
And the stand of the state government, that affidavit is filed when?
They filed without.
We filed the affidavit on 20th of June 2024.
Who is the person who is?
He is Sanjeev Kumar Bora, Secretary to the Personnel Department.
But in the writ petition, the state government did not file their affidavit. Of course,
In the writ
petition, asked them to keep their stand. That is how that affidavit was filed.
But the selection is done by APSC, not by the government.
Yes.
And as per the APSC list, they are shown as selected candidates.
I respectfully disagree with the submissions made on behalf of the appellant.
No, we'll come to that.
Logic.
Please answer the query.
Yes.
Appointments are to be made from the select list prepared by the APSC.
Yes.
APSC is a statutory body.
Yes.
It is discharging its statutory function.
Constitutional body.
This participation in the mains is on the strength of a court order.
Yes.
That order was never challenged by the state or the APSC.
No.
See, answer the question, Mr. Nath. You give your opinion when you argue. No problem. No challenge.
I'm agreeing with that.
Yes. So they were allowed to participate. In the meantime, whatever rights have crystallized, APSC recognizes that right, which is the statutorily enjoined body to do it, not the government, and makes a recommendation in their favor. The question is, can these now be taken away because the government says we don't agree with the APSC's view? That's the only question here. Because if you had a problem with that, you could have assailed the interim order passed by the court, which you did not. Every order of the court creates some right, whether it is interim or final. Now, this is a salutary principle that court order cannot prejudice anyone.
Yes, actus curiae nemmim grave.
Yes. Now, you have allowed them to take part, despite knowing that they had not cleared the prelims as per the APSC selection.
APSC has the
Correct. APSC gave a view that this is a screening, so there is no difficulty. Nobody else is before the court saying that in our case, Article 14 has been violated. Why should the court take a negative view in this matter? After all, it is a question of future of some young people.
Well, the interim order merges with the final order. The writ petition was dismissed. That is number one.
Correct.
And Malad, the minutes of the APSC that Lordship may kindly see in a meeting they have taken a decision that perhaps these particular candidates can be considered. That is their minutes.
It's not. These are all fine. We know.
Lordship.
What is the principle on which you are taking this stand? What is the principle?
Malad,
tell us that.
Kindly see paragraph 4. We have said, Malad, paragraph 4.
Here is the principle. Paragraph 4, 5, you read it. What is the principle on which you are taking this stand?
But this recommendation of the APSC is a recommendation to us, and we have to see whether they are properly selected or not. That is number one. And secondly, the Assam Public Services combined competitive.
So why do you think they are not properly selected?
Because
They did not clear the
They did
screening
not
test.
clear the prelims.
Why did you not challenge that interim order of the learned single judge?
We said that the interim order, ultimately the writ petition was dismissed and it merges with that, and we are with the final order.
Correct. So if we allow the writ appeal, then it is over.
But the Assam Public Service combined.
Yes, sir.
Logic.
Now this
So minus one of that, there is no recommendation. Only that minus. Knowing that they were not taking it well. So, matlab, in a but the things on competitive The substantive argument. APC में ये देखो वो state के लिए ये bad president
So your only argument is it will create a bad precedent.
No, that is one.
That is what.
That is one, and that apart from that, in paragraph, in the affidavit, we have taken a stand. Then the other relevant fact is not the honorable, the learned single judge has also directed not to publish their result, and to my understanding, there is no such recommendation as on date in favor of the appellants, and my lord, Lordship has directed the department to clarify the stand that, and while clarifying the stand, we have said, my lord, that the Assam Public Service Combined Competitive Examination Rules 1989, which is a statutory rule, my lord, under 309, 1989 rules under which, my lord, the selection has been done, there is no provision for such relaxation. Whatever in the minors they have considered, they have said that preliminary is just screening only, so that may not be considered. Only since they have cleared the mains, that they may be considered. That is what they have opined in a meeting.
They can be considered as a one-time measure without.
It is a view taken by the APSC in a meeting. So in the affidavit, we have said that 89 rules, there is no provision for such relaxation. Combined competitive examination, the selection has to be done. It consists of combined competitive examination preliminary, nor any provision for conferring any such power of relaxation upon APSC to select such candidates. So that is what this stand, only referring to the particular rule under which APSC has conducted the selection. So therefore, we have said, that the views which the state respondent cannot agree with the view of the APSC.
What we have gathered from this affidavit, such instances in line,
if
the image of the government in the public eye, as well as I demoralize the aspiring civil candidates. Moreover, it will create a bad precedence in future.
That
This
is,
what you are
that is also a statement made in the affidavit, but kindly, Lord, if Lordship kindly allows me, I'll read the paragraph, Lord. Kindly permit me to read the paragraph, Lord, paragraph 4.
There is a merit list published.
Yes, yes.
Is that only?
Lordship, the kindly come to page number 311 of this paper book, my lord. The file which the Lordship is holding. Please come to my lord 313, para 1.3. Because there was a direction by the learned single judge to asking the APSC to place their stand. Para 1.3. The matter was again discussed by the commission in its meeting dated 25/1/21 in pursuance of the order of the Honorable Guwahati High Court passed in WPC. So, if I kindly come to the first subparagraph. With regard to petitioners in WPC so and so, the commission opined that the Honorable High Court in interim order allowed both the petitioner to appear in CC main and they cleared both the CC main and viva voce by securing position in the final select list by virtue of their own merit. As such, commission in respect of these two petitioners leave the matter to be decided by the Honorable Court, and hence the commission have nothing to object to any decision taken by the Honorable Court by considering the fact both the writ petitioners have qualified for recommendation by a commission on assessment of their respective merit in CCMs 2018 and interest. So my learned friend's statement that our name did not appear in final select list is not correct. In fact, my lord, even posts were also allotted, but those were kept on hold.
But posts were also been allotted.
Yes,
to all
different
these
services, yes.
Where is the?
Even now,
Where is that?
in the interim order of this Honorable Court, of the division bench of this Honorable.
Respective services were not disclosed, but high court were.
6 in all.
Which is that order?
1 second, Mila.
Redaction number 351 of 20. 403. We have prevented from declaring the results of sheet candidate.
22nd of September 2023. In the meantime, the post in question shall not be filled up.
Yes, 22/9/23.
That is in one petition.
No, all the cases it is there. Similar. The direction that the post in question shall not be filled up till the next day. And that order is continuing.
This is order 22, 12, 20. Till today, we recommend those candidates. It was done as per order of the court.
Yeah.
For order of the because in past in I, we are unable to declare the results of 6 candidates. Till today, their name could not be recommended to the government.
But later on, now in affidavit you have said that they have cleared the examination and the main examination as well as the viva voce also.
But result could not be declared as per the order.
So if these petitioners don't succeed, these appellants, then what will happen to the 6 posts?
It's up to the government.
But in the next election, that will be included, my lord, in the next process, my lord, subsequent process.
Next selection, हुआ है उसके बाद में?
Yes, my lord.
Yes, my lord. In fact, one was already over last year. Even this time also, the
A
main
process
result is, I think,
A process is going on.
And the appellants did not participate in the success.
In item number 12, the candidates who are selected in the subsequent He got selected.
But who are lower candidate?
Whatever it may be. Selected and then you withdraw.
No, I don't know. But she was selected, ACS melody in this election.
And the two clients whom we represent, my lord, they've already both have become A's bar. Yes, P61 and. Item, yes, item 13 and item number 14, both the candidates have become A's bar.
बीच में जो आ रही है उनके नीचे है
Benchmark करने के benchmark करने के 40 लेके आया था 40 लेके 40 लेके आया
What about your seniority and all?
batch wise seniority will follow.
Now, after that, two batches have already been come.
Yes.
Has already been inducted. Now they'll come case how these.
Anyway, my lord, that we leave it to lots. I think because can be changes method.
Suppose in case if we order for giving you appointment, then your seniority will only be reckoned from the date of joining. Appointment or joining, whatever.
Miller.
You will be placed junior most in the cadre.
Junior most in the cadre. Irrespective of the merit position.
Not of 18. You mean to say no, not 18. Because now thereafter the
two selections have
already the people will again come guess how these persons will be
Later, that's because anyways they will later gather for the 19 and 20
I think, my lord, we'll forego that, my lord, seniority position according to the merit. That we can, because we have not joined. Of that batch will be the junior most.
Acha, what is the finding of learned single judge on your plea that the answer keys were wrong?
As such, no finding, my lord. Learned single judge has dwelt more on the point that there is no provision for relaxation.
He has not even discussed that. This
Not in so many words, Miller.
No, so whatever in not so many words, but whatever the words, whether
Basically, the learned single judge's view was there is no scope for any relaxation because we have not passed the.
What about this answer key?
Answer key has not dealt with, my lord, property.
Not there.
No.
There are two petitioners. We
know what the problem is. End of the day, my lord, we all stand on the same footing because they have also not cleared. We have also
You are on
not
the same footing on one point that you failed to clear the prelims examination.
Yes.
All of you, that is the.
And for us, at least the proximate cause is known that we did not secure the qualifying mark. And we say because the answer key was wrong. And my lord, we have given the evidence based on the, my lord, authorities. Why we say what we attempted right answer. And everything is indicated.
And what is their response to your plea that answer key is wrong? APSC?
We have denied and we have taken as part wise and regarding our authority and their authority. And even we have stated, even if they are awarded those two claim marks, they could not succeed because they will be below the minimum. From that answer key, they will not be finished. Eight employees in a piece.
No law,
para one.
No judgment as okay. At two. At two.
My lord, there is a one judgment by your lordship also reported in 2019 for DLR. Rishikesh Da on answer key. Reevaluation, scope of reevaluation.
At two. At two.
My lord, regarding that actual position as to how many posts were hold up and not, I've given an order of the learned single judge. If your lordship can we have that? Page 2 of that order. This was the order dated. Also quite longish order. Page 21. Page 21, my lord.
Yeah.
The first subpara. The state government in terms of the advertisement number so-and-so dated 17/5/18 and addendum dated so-and-so shall not fill up 3 posts of ACS out of 138, 1 post of Assam Land Revenue Service out of 56 posts. My lord, that order of the learned single judge passed in IA, page number 21 internal, my lord, of that order. Last page.
The page number 20.
Yes.
Yes. The state government. In
The
terms of
state government in terms of the advertisement number so-and-so dated so-and-so and addendum shall not fill up 3 posts of ACS out of 138, 1 post of Assam Land Revenue Service out of 56, 1 post of Inspector of Tax out of 32, and one post of labor inspector out of 11. Possibly, my lord, because we are not privy to the final result, because ABSC submitted the results in and all before the single judge. Having noticed, this order was passed. So this is how, my lord, the posts are retained.
So this, three posts in the
Assam Civil Service.
Assam Civil Services, which are these three petitioners?
That was not disclosed. That was not disclosed to us.
And one post of ALRS, that is
Yes.
also not clear.
No, we do not know. We are not aware.
An inspector.
One inspector of tax and one labor inspector.
They have also not mentioned in the affidavit regarding.
No. Because the learned single judge was, maybe that records reveal this. That's why, my lord, this order was passed. But I'll rely on three judgments of the Supreme Court, my lord, on the scope of your lordship's power.
Mr. Constable, the APSC. The details that which person is selected against which post.
Two petitioner lordships. One has selected for SCS and one for ALRS. Some land and execution.
Who are these two petitions?
Maybe lordship, maybe at this stage.
Why maybe? You select.
Salini Khan and Irvani Deka. Salini Khan and Irvani Deka. They one selected for SCS and one selected under ALRS.
And the other one is selected this post of inspector.
Out of four, two selected under cadre of SCS, one as a tax superintendent and one as a labor intendant.
So which person is selected against which post? Or scrutinize for that thing?
This 10 minutes time may be allowed. I will bring that.
You do one thing. You give us a note that this petitioner was selected against this. Give us a note. Yes.
My lord, regarding the scope of that screening test, my lord, the rule itself prescribes, it's not a question of any discretion. That 1989 rules, if your lordship would kindly have this book, take it up on the
Service manual.
service manual. Assam Public Service Combined Competitive Examination Rules 89. Page 143. My lords will kindly come to page 151. Appendix 1, section 1, 2. Page 151.
Yes.
Preliminary examination will consist of papers of objective type multiple choice question and carry maximum of 200 marks each of 2-hour duration as is set out in section 2. This examination is meant to serve as a screening test only. The marks obtained in the preliminary examination by the candidate who are declared qualified for admission to the main examination will not be counted for determining the final order of merit. The number of candidates to be admitted to the main examinations will be 11 to 12 times the number of vacancies to be filled up in various services and posts. Only those candidates who are declared by commission to have qualified in the preliminary examination will be eligible for admission to the main examination of that particular year, provided they are otherwise eligible for admission to the main examination. I have placed this provision for the proposition that it's a screening test. Now, if your lordship would kindly come to page 33 of the same book, my lord.
Yes.
That's the relevant service rule for the Assam Civil Service. If your lordship will kindly come to rule 5.
Page?
At page 35. That's the relevant recruitment rule to the Assam Civil Service.
Yes.
Recruitment to the service shall be made in the manner prescribed hereinafter. Recruitment to the cadre of junior cadre shall be made by the following method, namely, by direct recruitment through competitive examination. We are concerned with this. Then my lord will kindly come to rule 6 on the next page. The direct recruitment shall be made at page 36. Direct recruitment shall be made on the basis of recommendation made by the commission in accordance with the procedure hereinafter provided. Now please come to D. The commission shall prepare a list of all candidates who qualify in order of merit in accordance with aggregate marks obtained by each candidate. The number of candidates to be recommended for appointment may be decided by the commission. Keeping in view the number of vacancies, commission shall forward such list to the government. Now, after the list is provided, my lord, as far as government's role is concerned, it is confined to 7, 8, 9, and 10. Rule 10. The situation visualized by rule 7 to 10 are the area where state has a role. Whether there is a proper police verification or not, whether physically fit or not, academic qualification and all will be verified. But regarding government, perhaps, my lord, once a merit list is prepared by the Public Service Commission, which is a constitutional authority, I don't think state government can, my lord, have any say in the matter. I'm not saying, my lord, in that sense, but then normally that's the, the scheme of things. In an appropriate case, of course, but having regard to the facts of this case, my lord, perhaps it is not called for. So, my lord,
Page 147.
and page
Not 147.
147. You go for what? And if your lordship would kindly come to page 147, my lord, that part of that 1989 rules, rule 8. The decision of the commission as to eligibility or otherwise of a candidate for admission to examination shall be final. Yes. And if your lordship would kindly come to rule 3 also, my lord, of that rules of 89. Perhaps it will throw some more light, my lord. Rule 3. Notwithstanding anything contained in the Assam Civil Service Class 1 rules 1960 and so and so, so and so, so and so rules, and any other service rules relating to services and posts mentioned in Schedule 1, the commission shall hold combined competitive examination every year for selection of candidates for recruitment to these services in accordance with the procedure laid down in Schedule 2. The commission shall, after main examination, prepare a merit list of candidates and forward such list to the government for appointment to different services under respective service rules.
So in this case, is there a merit list forwarded to the government?
Yes, wherein our name appears.
I think actually not correct.
Why? That's why Leonard Singhal just says keep so and so post. Exactly, that is the merit list.
No, Mr. Datta, see, there is no clarity on this. We are asking again and again. If there is a merit list prepared, forwarded to the government, where the names of the petitioners are included, then the principals will have application in one manner. If there is no merit list, then it is a different matter. But if there is no merit list, then from where have you appointed the other candidates? Except this 6.
My lord, the fact that Laneth, I'm sorry. কোর্টও বুঝছে না হ্যাঁ দেখুন তোদের দেখি এখানে তিনটা এসিএস থাকে ওকে
He's unable to, that's why the record of the merit list,
You must have forwarded a select list, either including their name or excluding their name. Possibility is that you have forwarded the merit list, including their names, therefore the learned single judge has
Exactly.
bifurcated that these posts be kept reserved for that. Appointment could not be given on account of this pendency of this litigation.
Lordship, we have appeared.
No, but if their names were there in the list, why has the government not appointed? Is there any stay order, any restraint order?
No, my lord, because of the stay order by the Laneth single judge.
Saying
Result may not
The
be,
one I have read, my lord.
result may not be published.
Yes. Lordship, declare the result of whole number, so and so. With the paragraph before, the paragraph where taken close to the.
Otherwise, my lord, where from the Laneth single judge got the information that 3 ACS has cleared, 1 ALRS has cleared, and 1 superintendent of taxes, 1 labor inspector. That is why. Maybe because of the Laneth single judge's order, APSC, while forwarding it to the government, there our names have been withheld because of the Laneth single judge's order. That is the position.
Produce the merit list which you have forwarded to this.
We have placed our merit list as selected before a single judge.
You place it before us also.
I'll place.
You place it before us.
Clear to the I'm submitting, and the honorable single judge has directed us to forward the other regarding this fifth document.
Yes.
So to the government, we have sent those 255 candidates, except this fifth candidate.
Excluding their names.
Yes, that is the position. My learner is correct.
The name of.
So you produce that merit list.
It's part of the report. It's there in the registration. I'm sure it's there. As well. It's the final list for 24th December 2020. Your name is not there. Correct, because there's an interim order. But in my appeal, it's a page 80. With appeal.
15, item 15.
But anything is done when they are selected. Yeah, please. But see, that is very- but this method is the reason they are- Return on recommendation.
Doctor, may I just show you the 22nd December order, which is at page 105.
Give me a hand.
22nd.
Page 105, Lordship of this. It's the same order, Your Lordship.
The same order here.
Yes, yes. It's the paragraph, there's no paragraph in this order, which is why I'm finding it difficult to.
Page number.
Lordship, internal page number 21.
Yeah.
Yes, Your Lordship. The first paragraph itself. May I read from page 20, last line? After hearing the learned counsel for the parties and considering the matter in its entirety, the applicant APSC is directed to publish the results of the combined examination 2018 pursuant to advertisement so pertaining to 255 candidates. However, the applicant APSC shall not declare the result of the roll numbers 10 so and so out of the 3 writ petitions and presently pending before the court, and roll number so and so, 2 of which is us, among the 8 of the 68. So there was a direction not to declare. Thereafter, they say not to file. And Lordship may find page 80 is the result, which has been declared after the pursuant to this order.
Page
80 of our writ appeal. This does not have our name because there's a direction not to declare so and so.
So how do you know that your client has been selected?
Lordship, we did not. That is our problem. Lordship, we are now turn to page 91.
No, now today, how do you know?
Page 91.
APSC affidavit of the bond.
And the interim order, that's our roll number, Lordship. Lordship, page 21 of the interim, Lordship, the roll numbers are there. They categorically said to not declare so and so roll numbers.
We find out at page 91 when our names are not there and we discover there's a writ petition pending. Page 91, there's a small note. This is in compliance with High Court order of 22/12/20. That is how we come in, Your Honor. And we filed an detention. I'm talking about item number 15. The 98, 4 out of 98. Lordship has page 91, the note. It says the above result has been declared in compliance with so-and-so order. The order which is 22/12/20, which I just read out.
These are your clients. They are your clients.
Lordship, two of them.
Which two?
Lordship, page 21 of your interim order. Lordship,
These 91, there are names of 3 candidates. You are not.
no, the final select list does not have any of our names because there's a deck.
That's why only you approach this court.
Yes. No, we moved, we inquired. Then they said there is an order. Then we saw this order. Then we discovered our roll numbers. And our roll numbers is 120,895 and 110,550. After reading this order, we first time discover that there's a matter pending and our results have been declared, directed not to be disclosed. And we had.
They were party in that petition.
We were not never party. APSC, Lordship, APSC by way of 4 affidavits, 3 minutes from 2019 to 2020 took a stand that we stand by.
Don't publish the result, because the free published. That is the only publication. This is all telling you. मना किया हो सभी करते हैं. चार चार से ये कुछ why they have created a thing to only to family and get on ये पेन तो फिर करता है ये तो आंसर की को लेकर 18 पे 20 में लास्ट निकलता है
Madam, you just clarify what we have gathered that your these four clients, this Anupam Deka, Manish Barua and so and so, so and so, they.
Anupam Deka and Vidita Bore.
I'm appearing for Saswati and Manish Manas, the other two.
Okay, so these four persons appeared in the prelims examination. They cleared
They
at
were
the
notified as being
selected.
for pay. They appeared in the mails.
The mains, man, then how they have been ousted?
Lordship, they've been ousted by the single judge for the first time.
No, I'll clarify. What had happened, Madam? Initially, there was the first answer. As per the first answer key, there were a lot of candidates who were selected.
We were including these four.
Yes, we four were included in the first answer key. Thereafter, my lords, the answer key was revised because there were large scale hue and cry, whatever, my lords. So after the revision of the first answer key, there was a second answer key published, my lords.
406.
Yes, as per the second answer key, there were some additional candidates who were included to appear in the mains. But my lords, due to the application of the second answer key, there were few candidates who ought to have been eliminated, who were initially selected. But the APSC stand was that it won't prejudice the candidates who had selected as per the first answer key.
Okay.
So the names were not declared. Who were those candidates?
Okay.
There were 98 candidates. Thereafter, my lord, during the course of the case, my lord, it was on inquiry made by the learned single judge that who were those people who ought to have been ousted, but the APSC did not oust them. Give a list of those persons.
Then these,
and out of those, there were 98 persons, my lord, and it was siege, my lord. We never got an opportunity, my lord.
And APSC took their stand in 98 wow.
My lord, in the list of dates which you have given today, we have brought out all this clearly.
Lordship, I see page 73. Then you find out without prejudice clear of addition of 98.
In an affidavit only, the APSC came up with a stand that out of this whole lot, there are 98 who ought not to have cleared the prelims.
that is
But you
at the insistence of the learned singers.
And actually, we have brought out everything in the list of dates which we have submitted, Miller, chronologically date wise.
Judgments.
Yes.
Just one query before you leave, move on. See, it says 11 to 12 times. So it's not a fixed cutoff. It's a variable
yes,
cutoff.
Yes.
Even if this 98 is not excluded, then also it fits into the scheme of the rules, 11 to 12%.
Yes, yes.
And this rule is standard. That means you can rely on that 11. So preliminary screening where you fall for more than actually required.
That is 11 to 12 times. It's not a fixed percentage.
That was successfully explained by learned senior counsel, Mr. N. Doctor, who was appointed as the amicus curiae.
Yes.
He had submitted that it would prejudice no one. And that paragraphs are there, I'll place it if required.
Lord, the citations which I would like to rely upon. First is, my lord, 2013 4 SCC 690. Now, my lord, please come to para 5 and 6 for the facts at page number 693. Same situation, wrong answer key. In the writ page, my lord, 693, para 5. In the writ petition filed by the aggrieved candidates, a single judge of the High Court referred the model answer key to the experts. The model answers were examined by two experts so-and-so associated with NIT Patna who found several such answers to be wrong. In addition, 2 questions were also found to be wrong, while 2 others were found to have been repeated. Question 100 was also found to be defective as the choice in the answer key were printed out only partially. Based on the report of the said to expert, a single judge of the High Court held that 41 model answers out of 100 were wrong. It was also held that the 2 questions were wrong while 2 others were repeated. The single judge on that basis held that the entire examination was liable to be cancelled, and so also the appointments made on the basis thereof. Certain further consequential directions were also issued by the learned single judge, asking the commission to identify and proceed against the persons responsible for the errors in question paper and the model answer key. Anyway, my lord, the matter went on. Then my lord will kindly come to para 21.
Mr. Chaudhary. See, whether the answer key was right or wrong, we are not getting into that.
Then my lord,
so don't make any.
Okay.
We will only see what is an equitable approach. here.
Exactly, exactly.
Whether there
And
is
for
an
that,
issue.
my lord, in that case, I'll rely on
And
one
what does
judgment.
the rule say?
Yes. My lord, 2019-16 SCC 663, power of this honorable court in such a situation, my lord. 2019-16 SCC 663. This honorable court in an appropriate situation is not helpless, my lord. As a court of equity, lordships can always come to my lord undo the injustice. Para 20. This is the precise answer. 2019-16 SCC 663, para 20. Para 20 at page 670. The question, however, arises whether even if there is no legal right to demand re-evaluation as of right, could there arise a circumstance which leaves the court in any doubt at all? A grave injustice may be occasioned to a writ applicant in certain circumstances. The case may arise when, even though there is no provision for re-evaluation, it turns out that despite giving the correct answer, no marks are awarded. No doubt this must be confined to case where there is no dispute about correctness of the answer. Further, if there is any doubt, the doubt should be resolved in favor of the examining body rather than in favor of the candidate. The wide power under Article 226 may continue to be available even though there is no provision for re-evaluation in a situation where a candidate, despite giving correct answer and about which there cannot be even the slightest manner of doubt, he is treated as having given the wrong answer, and consequently candidate is found is entitled to any marks. So, my lord.
Mr. Datta, the rule says 11 to 12 times. Correct. So what will be the 11 times and what will be the 12 times in this case? Can you give us the figures?
260. So 261 into 11 and into 12.
So how many people have been allowed to participate in the mains here?
That numbers perhaps.
That is there, my lords, in an order, my lords, 3 paragraphs. That
Where is it?
Yes, my lords, the order dated, second report. My lords, the order is order dated, just a moment. My lords, order dated 9/10/2020, and the relevant paragraph, my lords, it starts from 36.
9/10/2020.
2020.
In the learned single judge's file.
Succinctly explain, my lords, the position, my lord, by the amicus curiae.
कुछ सस्पेंड है तो उल्लेख पढ़ने की रीड पिटीशन फाइल पर नहीं गया था नहीं रीड पिटीशन फाइल के लगी वो
Order dated
2010 9/10/2020. 32228 of 2019. Nobody is affected. These two meet by a whisker. They just. 9/10/2020.
मतलब इसको मतलब यहाँ पे पिंग इफेक्ट जो इससे ज्यादा मार्क्स को किया है फीलिंग और they could address that
Now, you just show the judgment regarding that, how the Supreme Court has interpreted this preliminary examination process. This 2008 for SCC.
2008 for it.
Yeah, read the relevant.
First, paragraph 5 is what the facts are. And basically, there was a challenge at the preliminary stage and there was a challenge. So what they did was they deleted all the contentious questions and they prorated mark. That was the clearly paragraph 5.
What the Supreme Court has said about this, this assessment or whatever the examination.
And the scope of preliminary examination. Purport.
Paragraph 23, paragraph 21 onwards is the finding.
21 onwards. Now read.
Paragraph 23.
Read. Paragraph 21 onwards, read.
Having heard the learned counsel for the parties and having given anxious consideration to the rival contentions raised by the counsel, in our opinion, no case has been made out by the evidence to interfere with the orders passed by the single judge and confirmed by the division. As observed by the High Court, the combined services preliminary examination 2005 was held in Jammu and Kashmir Public Service Commission for selecting 132 candidates for 18 gazetted service as notified on 1/4/2005. For making selection of the candidates for direct recruitment, the basis was the combined competitive examination. In exercise of the powers under subsection 1 of section 133 of the Constitution of Jammu and Kashmir, the Commission framed rules known as the Jammu Kashmir Public Service Commission Business and Procedure Rules 1980. They inter alia provided procedure for transaction of business, forum, decision of commission, recording of minutes, etc. The procedure for conducting such examinations was governed by the rules known as Jammu Kashmir Combined Competitive Examination Direct Recruitment Rules 1995, issued under so and so. The rules of 1995 emphasize the combined competitive examination into successive stages. The combined services preliminary examination objective type for selection of candidates for the main examination screening test. Combined services main examination written and interview for selection of candidates for various services and post selection tests. This is exactly the same. Our rules also provide for 2 days. 400 marks, main is 1600 plus 200 interview. 23 is what is important. The preliminary examination consists of 2 papers. Compulsory paper of general studies and an optional subject chosen by the candidate out of 22 specified optional subjects set out in Appendix 9 of the rule. Preliminary examinations was meant to serve only as a screening test, and the marks obtained by the candidates at the preliminary examination were limited to get entry and to be treated as qualified.
That itself, it itself says the same thing. Same thing.
Yes, Lord.
That
The number of
Where is that additional discussion by the Supreme Court that the preliminary examination is only for shortlisting and therefore it can be ignored or something like that?
this is what this is the finding of the Supreme Court.
That is this
we have-
appendix,
we have-
that appendix also speaks about this.
we reiterate that.
The preliminary examination will consist of paper so and so. This mark examination was as a screening only. The marks obtained by candidates who are qualified will not be counted. This is what they have already provided.
Dr. Nair, complete this paragraph and come to the next paragraph. So the important of 1 is 30. Are not the number of candidates to be admitted to the main examination on a basis of preliminary examination, one is in the ratio of 1 to 30 of the total approximate number of vacancies to be filled in various services. It is also provided in the rule that only those shortlisted candidates will obtain such mark in the preliminary examination as fixed by the commission and discretion and prepared by the commission as qualified in the preliminary examination are allowed to appear in the main examination provided they were otherwise eligible for admission to the test. Then not to wait 47, paragraph 47. Which is what I, after noticing this, then paragraph 47.
Yes.
The last 3 lines. Last one. The last 5th, in our view. Paragraph 47. In our view.
Yeah, the learned signal.
The learned signal is right. It is clarified by the commission that the selection was not based on preliminary examination. It was relevant only for the purpose of qualifying and getting entry into the second examination, the main examination. In other words, it is in the nature of screening tests and selection or merit was not to be merit was not to be based on the result of the preliminary examination. Again, as far as the commission is concerned, the commission is not taking any decision in favor of or against any individual candidate, but was in the nature of a policy decision. Keeping in view large scale complaints against special paper, general action was required to be undertaken. It was necessitated to ensure that no candidate suffer and that there was no cause in the solution. If any, all the members of the commission of the can take an appropriate action. Also, there was an allegation of bias because one particular member did not participate, or he had one of his relatives participating, that he should have actually kept off. This is not relevant for us, but this is more that it's not biased. Paragraph 48. We are not impressed by the argument of the learned counsel for the petitioner that by conferring benefit to those who were unsuccessful and by not extending similar benefit to successful candidates, any injustice is caused. Because the pro rata mark was only given to the unsuccessful. Successful candidates did not benefit. So we are not impressed with the argument. Firstly, candidates who were successful at the preliminary examination have not raised this plea. And we're surprised as to how such a contention could be raised by unsuccessful candidates, even though they got the benefit of the additional mark. Similar benefit was not given to successful. But even otherwise, and this is important, even otherwise, the contention is not well taken. As already noted, preliminary examination was the first step and was limited to the process of shortlisting of candidates in the ratio of 1:30 and was not relevant for final selection of the candidate and preparation of the merit list selected. The marks obtained at the preliminary examination were not to be counted for final selection and preparation of the merit list. It was limited to getting entry in the main examination. It therefore cannot be said that by not granting benefit of additional marks to selected candidates, which were given to the unselected candidates, injustice has been done. So I think paragraph 48 is, after noticing everything, the finding that the entry point is not, and this is the stand taken by APSC in their affidavit. And this is what the rules provide for. The final decision for selection is the APSC. And for these examinations, APSC section 3 is the sole body who's supposed to do it. Government is only supposed to check for academic verifications and medical but the 2010, which also emphasizes the discretionary power of the APSC. May I place it?
Yes.
The Assam Public Service Commission proceeded and conducted business rules, and they reiterate what the seven treated rules that we read out. Rule 15.1. It's a repetition of exactly what you said. Other Assam 1000.
Rule 50.
51. Preliminary examination is to serve as screening test only and comprises of multi-optional objective type questions. The number of candidates we admitted to the main examination will be 11 to 12 times the number of vacancies people having regard to various designated categories. A lot of what is important is 77. The commission may, document 77.
Yes.
The commission may deal in such matter as they deem fit with any matter. Commission may deal in such matter as they deem fit with any matter not specifically provided in these rules. So the final discretion is the commission. Also, this one more judgment, just one paragraph. This is not preliminary examination, main examination, and this is the law on when you can do revaluations. Just one paragraph which might just throw light on our situation. Paragraph 32.
2018 to SCC.
Yes, Your Lordship. 2018 to SCC 357. This is more on re-evaluation and when you can do re-evaluation. So there is one paragraph I'm relying on. Paragraph 32. Because like our matter, the matter went on for about 8 years. May I read paragraph 32? It is rather unfortunate that despite several decisions of this court, some of which have been discussed above, there is interference by court in the result of examination. This places the examination authorities in an unenviable position where they are under scrutiny and not the money. Additionally, a massive and sometimes prolonged examination exercise concludes with an air of uncertainty. While there is no doubt that the candidates put in tremendous effort in preparing for an examination, it was not forgotten that even the examination authorities put in equally great effort to successfully conduct an examination. The enormity of the task might reveal some lapse at a later stage, but the court must consider the internal checks and balances put in place by the examination authorities before interfering with the efforts put in by the candidate who has successfully participated in the examination and the examination authority. The present appeals are a classic example of the consequence of such interference where there is no finality to the result of examination even after a lapse of 8 years. Apart from the examination authorities, even the candidates are left wondering about the uncertainty otherwise of the result of the examination, whether they have passed or not, whether the result will be approved or disapproved by the court, whether they will get admission in a college or university or not, whether they will get recruited or not. This unsatisfactory situation does not work to anybody's advantage, and such a state of uncertainty results in confusion being worse confounded. The overall and larger impact of all of this is that public interest suffers. Lordship, I'm relying on this paragraph to say that at the end of it, APSC has taken a stand that they have the discretion and that it is not any fault of 98 and that they should not be expected. And nobody has challenged, including the writ petitioner, nobody has challenged our inclusion. At the end of it all, the appellants are prejudiced in a writ petition which does not challenge their conclusion. And that is the situation after 2018 was the advertisement in 2024. Okay, may I read the latest APSC minutes? Because there were 3 minutes. The single judge.
The additional affidavit, they have filed that? Latest BSc minutes?
It's a part of record, Your Lordship. Page 351 of my opinion.
That they have placed on record that
18,381.
Yeah, 18,381.
I've read it.
Because there were 2 other Two other minutes, and the court kept going back to APSC, clarify your stand, clarify your stand. And APSC kept coming back to say that we reiterate and reaffirm, we ask.
They could not be clear by a whisker. This is what the.
Yes, yes.
These 4 candidates and these 2 candidates, they have said they're,
So
they
what
competed.
we know, appellate, only thing we know now today is by a whisker, we did not name. And then one more point on discretion. And 9 out of 21 petitioners came to this form when they did not find place, even after reevaluation. 9 out of 21 petitioners were given grace mark and allowed to participate. So, and the single judge allowed that. So to that extent, APSC was granted discretion to grant grace mark to 9 out of 21 and held to have qualified. So the single judge, my humble submission, went wrong in saying APSC does not have discretion because it allowed APSC to exercise discretion, weigh 9, grant them grace mark, and allow them to participate. We were not even given benefit of that. The only thing we know is by a whisker, we didn't make it. We do not know what is the whisker. Could we have benefited like the 9 out of 20? Did we come to court?
Millard, I was referring to that order, Millard, where the learned amicus curiae, Mr. Datta made on submission, just 3 paragraphs from that order. Millard. Please come to para 36, Millard, at internal page 32. Yeah. Para 36, Mr. Dr. Learned amicus submitted that pursuant to the advertisement so-and-so, as many as 36,232 number of candidates appeared in the combined competitive examination on 30/12/2018. On 13/3/2019, APSC declared the result of the preliminary examination, in which 3361 number of candidates passed the same. On re-verification of the answer key, additional 408 candidates passed, and the said preliminary examination as per its list dated 34/2019. On its verification, APSC found that after the revised answer key, 98 number of candidates out of 3361 did not obtain the cutoff mark in the said preliminary examination so as to qualify to appear in the combined competitive examination 2018. 21 number of such candidates who did not qualify the said preliminary examination even after publishing the revised answer key preferred 21 writ petitions. On re-verification, APSC allowed 9 petitioners, out of which those 21 petitioners to be qualified to appear in the said main examination. Remaining 12 petitioners have been allowed to appear in the said main examination by order of the court, subject to outcome of the writ petitions. Moreover, out of those ineligible 98 number of candidates, among 3361 candidates, only 68 number of candidates appeared in the same main examination and 30 did not, and altogether 3760 number of candidates appeared in the combined competitive examination conducted by the APSC. Mr. Dr. Learned amicus also submitted that out of those 3760 candidates who appeared in the said main examination, issues are related only to 80 number of candidates, which includes 68 candidates who did not obtain cutoff marks in the combined competitive preliminary examination after the revised answer key were uploaded by APSC, and the present 12 petitioners who did not pass the said preliminary examination even after re-verification of the said answer scripts in the said examination and are allowed by the court to appear in the combined competitive preliminary examination 2018 subject to outcome of the writ petition. Mr. Dr. SS submits that out of those 3760 candidates who had already participated in the combined competitive examination 2018, there are no dispute with regard to 3680 number of candidates. Now, Losimai, kindly skip 38, please come to 39. It is submitted by Mr. Dr. Learned amicus curiae that no one has challenged the decision of the APSC to allow 98 candidates out of 3361 who, after revised answer key pertaining to the combined competitive preliminary examination uploaded by APSC, failed to obtain cutoff marks to qualify to appear in the combined competitive examination 2018. And out of those 98 candidates, only 68 candidates appeared in the main examination and 30 did not. Similarly, there is also no challenge with regard to the present 12 petitioners who were allowed by the court to appear in the state 2018 main examination, subject to outcome of the main petition. Mr. Doctor stated that from amongst the present 12 petitioners and 68 candidates noted above, the number of candidates who might have secured cutoff marks in the state 2018 main examination, their percentage of qualifying, the same would be very nominal. So, my lord, this was basically what the amicus also stated, because nobody had challenged. So, at the end of the day, my lord, looking at the peculiar facts and circumstances of the case, we humbly submit, my lord, lordships will exercise your lordship discretion, and my lord, allow the matter to give a quietness by allowing us to join our respective services, my lord. And enough of enough. 6 years, my lord, we are only.
Status of that petitioner's lordship is asking to
So that's our humble submission, my lord. Oh.
The serial number is in order of merit.
No.
What is the merit position of these candidates?
Merit position, I will have to got that the original directly have merit.
In any case, my lord, supposing if your lordship is inclined to allow, we'll come the bottom of the particular that merit list.
2018 batch.
Even if our positions were high, that will not make any difference. We'll be counted towards the bottom of the respective service.
18 batch.
To 2018 batch.
2024. Start from this.
And then, as far as the two appellants I represent, my lord, I leave it to your lordship. I've got no comments.
Don't,
Yes.
you're also on a very sticky wicket. So
We'll leave it to your lordship.
if we allow them, subject to this, 2024.
Another case where they molded in such a manner that said, in fact, here they were not selected, they were below cutoff. They were actually selected, but they finally on re-evaluation discovered they were below cutoff. Then they say that we will not oust them. That is Mr. P.P. Rao's submission, that just because you're below cutoff doesn't mean you oust them. You put them at the bottom of the list.
This is true.
Rajesh Kumar.
Rajesh Kumar.
Order is there. Order is there.
Yeah.
Item 22.
For the petitioner.
Lordship, I am representing Mr. Tija Mohanto, Lordship.
Next available day.
Lordship.
All these matters next available day.
Available bench.
Available bench.
Item 4.
That bank wala.
Who is for the bank? Yes. Why you need 2 months time to comply the order?
Yeah, please, your lordship, basically earlier we have taken an opinion and thereafter we are on the verge to comply with the order. But since the disciplinary authority who has passed the order has already been retired, so the matter got delayed for appointment only, your
Who is
lordship.
for the other side?
Your Lordship, not
Have you
present
informed
today.
the other side?
Not today, Your Lordship, but earlier we have served the copy, Your Lordship. I think.
Morning, you were not there.
Yes, Your Lordship, I am very sorry, I was legs before. the-
SK Mukhtar.
There is.
Is there?
He doesn't have any update.
Sorry.
Now principally, they have decided to comply with the order.
Yes, my lord.
And they are seeking 2 months' time. So if you have any objection.
Sure, they have filed it on 5th of September, my lord. Only 1.5 months have gone. So 1 month can be given, my lord. Only 1.5 months gone. It was filed on 5th of September.
Filing of the.
The matter comes upon for consideration of the IA preferred on behalf of the applicant bank with a prayer to grant them 2 months' time to comply with the order passed by this court in writ appeal number 11/2018, white judgment dated 6/8/2024. So stop. Learned counsel appearing for the respondent bank has submitted that the bank has that the applicant bank has decided to comply, has principally decided to comply with the order passed by the order passed by this court. However, on account of retirement of the disciplinary authority, the respondent bank will take it will take some time to appoint a new disciplinary authority for the purpose of taking a fresh decision pursuant to the direction given by this court. It is submitted that for that purpose, the time may be extended to comply to enable the applicant bank to comply with the order passed by this court. Full stop. Well, then it concept for the applicant, non-applicant is not seriously opposing the IA number, the IA. Full stop. Having heard the learned counsel for the parties and after going through the going through the contents of the application, we deem it appropriate to extend the time. We deem it appropriate to grant 2 months' time to the applicant bank from the date of filing of this application, that is 5th of September 2024, to comply with the order passed by this court, white judgment dated 6/8/2024 in writ appeal number 11/2018. ये number
Can it be further 1 month, Your Lordship?
1 month हो गया ना?
It's okay. Your Lordship, today we will get.
Mr. Sharma, please tell your clients that though we have given the liberty to pass an order, they should not take undue advantage of this liberty.
No, Your Lordship, we are
If
not.
the idea is to somehow throw him out of the service without application of mine, then we will take appropriate stand and then there will be difficulty. Because there is no loss cost to the bank, that is the finding.
Yes.
So you have to keep that in mind. Just informing you because they had also come earlier with some prayer.
Yes.
Wait, His Lordship, I beg to mention item 25 in today's list. I appear for the private respondent. There's an interim order operating against us from 11/5/23. I'm requesting for a fixed date, my lord, before the next available date.
Whenever the next, whenever the date on the next, this bench is available, the matter will.
Interim will continue in this matter.
There was some urgency in this matter, but
Most probably in the next month, again, we're having this bench.
yes, because there is an interim order which is operating in their favor. These are manufacturing unit. There is a status quo order. And they suppress the material fact that on the basis when the court has passed an order, interim order, that notification was not there at that relevant time. And there was a status quo order, consent to establish was granted by us.
This is not a perfect matter.
Next month, someone will hear on that. Next month, we are having this bench. We'll hear on.
Till then, interim may be continued, Your Lordship.
Because there is a PIL, your lordship will kindly appreciate this is a PIL. And this is an order has been, there is an order which has been passed, a status quo order. Now all investments has been made. Consent to establish on pursuance to a court's order. Stay vacating, we have also filed.
Is item number this?
25.
25. The matter may be released on the green bench and be listed before the regular bench in
I'm deeply obliged.
Division bench one.
regular division bench one.
I'm deeply obliged.
In the next week. Interim order.
Interim order is extended to the next date.
I'm
If
deeply-
any, is
I'm deeply
extended.
Deeply obliged.
Deeply.
Yes. Yes, Mr. Counsel?
Yes, Your Lordship, may I mention item 24, Your Lordship?
Yeah.
Your Lordship, in this matter, I had moved an application. The IA has been numbered, but it was not listed. May I request if it...
We'll ask the registry. We'll ask the registry to get it listed. Huh?
Oh, very well, deeply
On
obliged.
the next date, whenever this bench is available, we'll list it.
Can it be taken up on some day, if I can mention it, or up
This
to...
benching, we are assembling again in the next month, we'll take up in the next month.
Obliged, Your Lordship.